Ladies and gentlemen, dear students and dear guests, and of course, dear virtual guests who cannot be here in person, but are streaming this event from their computers, I would like to welcome you to today's inaugural lecture at the University of Economics and Business, in German Wirtschaftsuniversität Wien, and I will use the shortcut WU in my further speech here in beautiful Vienna and the most wonderful campus in Europe, at least for me. My name is Tatjana Oppitz. I am the Vice Rector in charge of the university's infrastructure and also in charge of the digitalization agenda. As you may know, WU is the only university for economics and business here in Austria and is one of the largest in Europe. So we are quite big, as you can imagine. Our academic programs and research areas cover a wide variety of studies ranging from economics, business administration, management, and of course, business law. This evening, we will have the pleasure to attend 2 lectures from the field of business law. First of all, I would like to take the opportunity and to thank the Department of Private Law, the Competition Law Group, and the Competition Law and Digitalization Group for organizing the inaugural lectures this evening. WU organizes inaugural lectures to give our newly appointed professors the chance to set the stage for their research areas, to connect their academic work with the outside world, and of course, to welcome them here at our wonderful university. So, welcome. Moreover, I would like to introduce Professor Georg Kodek, the head of the Department of Private Law at WU here in Vienna. He will hold tonight's introductory speech. Professor Kodek is an alumnus of University of Vienna Law School and received his Master of Law at Northwestern University School of Law in the United States. He was appointed professor at the WU in 2007, and of course, Professor Kodek is the author of numerous publications in the fields of civil law, the law of civil procedure, and bankruptcy, and of course, business law. Besides his academic career, Professor Kodek has served as a judge at regional courts before his appointment to the Austrian Supreme Court of Justice in 2006. Ladies and gentlemen, tonight we will immerse ourselves into the world of business law, and it links to digitalization. A very fascinating area of academia, and please apologize, but I'm not saying this because of my background as a former executive of IBM. Ladies and gentlemen, digitalization has the potential to completely change the way our societies and economies function. The past months have shown how digital transformation affects all areas of our life, of our society, business, and of course, also of the universities. And although I am in charge, as I already said, of the digitalization here at the WU, I always emphasize that WU is and will continue to be an on-premise university. This is very important for us. However, studying, teaching, collaboration, and research happen, of course, in the digital world too. And even though this brings completely new opportunities, digital transformation also poses new challenges for us as universities. Now, ladies and gentlemen, why do I say this? I say this because digital transformation goes beyond the simple adoption of new technologies. It makes possible to provide services, supply goods, and life experiences, and to find processes and make accessible large amount of content regardless of the real availability of resources, pervasively creating new connections between people, places, and things. Furthermore, we should not forget the many and complex legal dimensions of digitalization, regardless of the industry. One question which comes up and has always intrigued me: is there such a thing like a fair competition in the IT industry? Moreover, how can public universities such as WU, who are of course consumers of digital products and services, compete against large corporations when they negotiate terms and conditions with them? National governments, as well as the European Union, are asking these and many other questions. I am convinced that the research in the field of competition law can help us find the right answers. Now, ladies and gentlemen, I would like to wish you a very nice evening, an interesting evening, listening to the inaugural lectures with our newly appointed professors and, of course, with Professor Kodek. But first of all, let me hand over to Professor Georg Kodek, who will give us a more detailed introduction into the newly appointed professors and today's lectures. Thank you very much for joining us this evening. Thank you.
Thank you, Madam Vice Rector, for your kind words. Ladies and gentlemen, good afternoon. I'm addressing you in English because this afternoon we are being joined by a large audience from abroad, and we would like, of course, to enable them to follow what transpires here tonight. The way this will work, I'm going to introduce Professor Robertson, who will speak in English, and Professor Eckert, who will speak in German, Fair enough. Now, inaugural lectures are always a pleasure. They are a pleasure for the entire university, and of course, they are a particular pleasure for the department concerned. Now, in our case, the Department of Private Law, as it is called today. But having our inaugural lectures today is a particular pleasure for us because it is a live event. Both professors, whom I'm going to introduce in a few moments, were appointed during the COVID-19 crisis. At a time when large lectures were not possible, we had stay-at-home orders, lockdowns as they are called in Austria, and a number of other restrictions. The newly appointed professors were not able to meet their staff, were not able, to meet anyone else on campus, not able to see their students, and perhaps worst of all, we were not able to meet them. So we were prevented from seeing our colleagues after they came to our university. So we are particularly grateful that today we have an opportunity to present our newly acquired professors, if I may use that term, to a broader audience. I'm also particularly pleased to present the two professors that we are welcoming today, because as the Vice Rector has already mentioned, I am standing here in front of you as a professional hybrid, being both a professor of civil and commercial law and a sitting judge of the Austrian Supreme Court. And the work I'm doing there is commercial law, company law in particular, that brings me to Professor Eckert, and cartel law or competition law, and that is, of course, Professor Robertson, which ties in very nicely. Of course, this is a pure coincidence, but nonetheless, I think it's very appropriate, and I'm very grateful that I have the chance to introduce these two professors to you here today. Now, let me start with Professor Eckert, und jetzt kann ich zum Deutschen übergehen. Professor Eckert wird als erster sprechen. Er stammt ursprünglich aus dem Hause Dorald sozusagen, also kommt aus der WU, hat sich an der WU habilitiert, als ich schon auf der WU war, mit einer zutiefst beeindruckenden Arbeit über internationales Gesellschaftsrecht, eine Arbeit, deren Lektüre ich jedem nur ans Herz legen kann, wo er den Versuch, und ich glaube über weiteste Strecken geglückten Versuch unternimmt, aus den Grundfreiheiten, aus dem Primärrecht der Europäischen Union zahlreiche Detailfragen zu beantworten. Er war dann zunächst als Privatdozent an der WU tätig, erhielt dann einen Ruf nach Innsbruck und es ist jetzt gelungen, ihn zurückzugewinnen. Seit 1. Oktober 2020 hat er eine Halbprofessur, wie das heißt, für Unternehmensrecht mit dem Schwerpunkt Kartellrecht am Institut für Unternehmensrecht. Diese 50% Professur ist in gewisser Weise Ausdruck eines Programms der WU. Wir legen ganz starken Wert auf eine enge Verbindung von Wissenschaft und Praxis, von Forschung und Rechtsanwendung. Und ein Rechtsanwender an vorderster Front wie ein Rechtsanwalt könnte dieses Programm nicht glaubwürdiger verkörpern. Insoweit ist Professor Eckert auch Idealbesetzung und vollkommenster Ausdruck dieses Programms. Schon in der allerersten Vorlesungsstunde in der Einführung betonen wir dieses Anliegen der WU, diese Verbindung, die zum Vorteil der Ausbildung und damit natürlich der an unserem Haus Studierenden gereicht. Von seinen sonstigen Arbeiten möchte ich eine einzige herausheben. Er hat sich nämlich, wenn ich jetzt sage, nicht nur mit Gesellschaftsrecht beschäftigt, würde das abwertend klingen. Gesellschaftsrecht ist ein faszinierendes Rechtsgebiet, dem man ein ganzes Leben widmen kann. Aber er hat sich auch mit zivilrechtlichen Fragen beschäftigt und etwa, und das ist eine weitere Schnittstelle, die mich mit ihm verbindet, zur Frage, die jetzt gerade durch eine Richtliniennovelle wieder akut geworden ist: Gibt es Schadenersatzansprüche wegen einer Verletzung von UWG-Vorschriften? Auch dazu kann er und konnte er sich und kann natürlich immer noch sich intelligent äußern. Wie überhaupt, ich habe ja noch eine persönliche Erinnerung an seine Assistentenzeit, wenn ich das hier einflechten darf. Es hat mich immer fasziniert, mit welcher Freude er juristische Fragen diskutiert hat. Und er gehört damit einer Spezies an, das ist nicht selbstverständlich, die sich nicht darauf beschränkt, selbstreferenziell irgendwas aufs Papier zu pinseln und in Zitierkartellen sich gegenseitig hinaufzuschrauben. Auch dieses Modell soll in unserer Zunft vorkommen, sondern der wirklich von Erkenntnisinteresse geleitet ist. Und daher freut es mich ganz besonders, wenn ich ihn heute hier vorstellen darf. Er wird sprechen, mehr verrate ich nicht, über wirtschaftliche Betrachtungsweise, ich vermute im Kartellrecht, und damit für jemanden, der sich auch mit Methodenfragen beschäftigt, letztlich um fundamentale teleologische Fragen wird es hier gehen, die eigene Betrachtungsweise nach der Zwecksetzung und den Anliegen eines bestimmten Rechtsgebiets. Lieber Georg, ganz herzlich willkommen bei uns. Wir freuen uns auf deinen Vortrag. Bevor wir aber zu diesem Vortrag kommen, and now I'm going to switch back to English, let me turn to Professor Robertson. I received, a few days ago, I received an email from her secretary kindly telling me what I could say when introducing her. Now, I'm sure the intention behind this email was very kind, but in fact, I did not need it because I was very closely involved in her appointment and I do know quite a lot about her CV. and not just her CV, but also when one follows one of her competition talks, one realizes she knows like a who is who in the competition law world. And everybody from maybe Australia to the United States and everything in between, they all know Viktoria Robertson. They join her competition talk and I'm sure many other activities. So this was really fascinating taking part in some of these events. Now, to give you a few hard facts, she studied law in Graz, Oxford and Zaragoza, and after graduation she worked as a university assistant and later as an associate professor in Graz, where she earned her venia docendi in 2019 with an English language monograph on antitrust law, competition law's innovative factor. And it is a real page-turner, if I may use that term, to the extent law books can be page-turners, but it is a real page-turner. It's a fascinating, truly fascinating reading. Now, she's also, she never stayed at Graz for a very long time because she was a visiting academic with a large number of institutions, the Max Planck Institute in Hamburg, the European University Institute in Florence, Stanford Law School, Oxford University, to name just a few. She was appointed in September 2020, so September last year, and at VU she heads a research group called Competition Law and Digitalization that emphasizes, of course, the importance our university gives to this new field. The Vice Rector has already stressed that. Now, her expertise is not only sought by universities, but it's regularly sought by national and international media. For example, the Austrian television, Austrian radio, newspapers such as Der Standard, Die Presse, the New Statesman, the South African Competition Tribunal, the Swedish competition authorities, and a few others. Of course, also including the Austrian Federal Competition Tribunal. Professor Robertson will speak about competition law, a green and digital future. And again, I'm looking forward also to her lecture, and welcome to you, Professor Robertson. Thank you very much. And now, ladies and gentlemen.
So, thank you, everyone. Good evening. It's a real pleasure to be here with you tonight, both here in the room to actually see real faces and online as well. Thank you so much to Vice Rector Opitz for her nice welcoming remarks, and to our department head, Professor Kodek, for his kind introduction. So I've been here at the Vienna University of Economics and Business, or as the Vice Rector said, we call it the VU, for a little over a year now. And while the pandemic has thrown quite a few challenges our way, I really appreciated the warm welcome that I experienced here. Tonight, I'm grateful to share this new academic milestone with you through my inaugural lecture. And of course, such an inaugural lecture is a challenge. I've got family and friends here, both online and in person, both young and not quite so young, who pretty much for the first time ever are hearing what I've been doing professionally over these last 15 years. Then there are colleagues here who are not competition law academics, and while they've come to know me well, they don't know the complexities of my research all that well. And then, of course, there are my friends and colleagues in competition law, both in academia and in practice, who would like to hear something new to make this worth their while. So, with all these considerations in mind, I decided to talk about something that touches us all, but especially the next generation, namely the future. And of course, I will stick to competition law. I will be talking about a future that will definitely be even more digitalized than the present is, and that hopefully will be more environmentally sustainable or greener than the present is. And I want to show how competition law can contribute to making our future and the future of our children greener and also more sustainable when we talk about digitalization. And this topic also nicely connects my research interests that date from before I joined the VU, which was especially digital markets and competition law, and it connects with what I've been focusing on more since joining just over a year ago, which is environmental sustainability and competition law. So let's now endeavor to sketch this green and digital future for competition law. Bearing in mind that there are so many non-competition law attendees here tonight, I first briefly want to set out what competition law actually is, in terms that I hope are also accessible to the younger generation. Then, I will trace the current antitrust discourse, which very much centers around environmental sustainability and digitalization. After this, I will turn to the central question of my inaugural lecture today. How can competition law contribute to a greener future that follows a more environmentally sustainable approach to digitalization? Or, to be a little more technical, what scope is there within Articles 101 and 102 of the treaty and within merger control to take such considerations into account? While this is a policy-driven question, it is also one in which the law and case law are developing in leaps and bounds, and I will address these ongoing developments with a view to reorganizing them into a coherent legal framework. So, how can you best explain competition law to those who have never heard of it before? In a free market economy, it is believed that companies deliver the best results when they are left to their own devices. However, a few ground rules must be observed in order for this to work. First, companies are not allowed to agree on anti-competitive outcomes. For example, it is forbidden that the 3 cinemas in a small town come together and agree on the prices for tickets and for popcorn. This is what we call a price cartel, and competition law will not allow it. Secondly, companies that are in powerful positions are not allowed to abuse those powerful positions. For instance, the only supplier of chocolate may not ask for extra high prices for that chocolate, even if they could. Third, competition law ensures that when one company buys another one, this does not hurt the market. So for example, when a big fish wants to swallow a little one, but there are not many little ones left, then competition law may step in and stop that. So these are the 3 main areas that competition law deals with: anti-competitive agreements, abuses of a dominant position, and merger control. There are, of course, more nuances to each of these, and we could also talk about state aid here as another facet of competition law, but this should be enough for tonight's discussion. So, now that we've established what the basic rules of competition law are, it's time to ask what competition law wants to achieve with these rules. What are its goals? Now, this already goes to the core of what I'd like to talk about today, because there's growing disagreement over this very fundamental question. And the antitrust discourse on a green and digital future has a lot to do with that. Let me first set out the traditional view of what we believe more competitive markets should and do deliver. From a broader picture, economic growth and development are at the center of any economics-oriented approach to competition law. Efficiencies, and in particular the efficient allocation of resources, are an important aim to advance economic growth. But we also need to understand that competition law is by far not the only means by which the allocation of resources can be influenced. Corporate law has a role to play here: investment policies, procurement, regulation, external trade policy, and intellectual property, to name but a few. They constitute the basis upon which the competition law system can build. On a more specific level, competition law strives for consumer welfare. Consumer welfare is thought to rise in particular when consumers pay lower prices. And traditionally, competition law is very price-centric, both in its analysis and in the results that it strives for. This is understandable because competition economists use price as their benchmark for various economic tests. And as long as they can quantify something in price terms, they can apply their usual analysis. But this type of thinking backfires when you want to go beyond low prices, as you arguably want to do when you strive for a green and digital economy. The better quality of goods and services is also thought to be brought about by competition, because companies compete to provide the best they can to win the business of consumers and customers. More innovation is seen as an important result of competitive markets, because new ideas will provide a unique selling point for goods and services, and innovation is also an engine of growth. Competition amongst firms is also thought to increase customer choice, allowing us customers to choose from a variety of offerings and choosing the one that best meets our needs. In the European Union, we also have the single market. So one of our main aims in EU competition law is to further market integration. And to be honest, that's an aim that has very little to do with competition law as such and is mandated by the institutional setup of the European Union. But this can also be a chance for a green and digital economy, as we will discuss a little later. Now, as I said, this traditional approach to competition law is being challenged by different schools of thought, by new influences from non-traditionalists, but also by the changing world that we live in. So what is this discourse all about? As we already heard from the Vice Rector, our lives have become enormously digitalized over the past 2 decades, and even more so over the past 18 months. And so has our economy. If you're joining us here in person today, chances are that you used Google Maps to find the lecture hall. If you're joining us online, you're joining on Zoom. So you're using a digital service that has made life during the pandemic much more manageable, and that has been our primary teaching tool over these past 18 months. Digitalization is no longer an abstract concept, it pervades our everyday lives, both in our workplace and in our private lives. At the same time, we are living in unprecedented times as regards the environment. Record floods, extreme heat, melting glaciers, and raging wildfires, they're all indicators that global warming is a very real phenomenon that we cannot further ignore if we want this planet and its population to thrive. And of course, these developments, both in digital and in green, have also impacted how we think about competition and competition law. The European Union has recently recentered its entire economic strategy on 2 pillars: digitalization and environmental sustainability. In addition to the broad sustainable development goals promoted by the United Nations, the EU is implementing an ambitious Green Deal that will touch upon every policy within the Union. While in January 2019, the European Commission hosted a conference on competition law in the digital era, this year, it hosted a conference on competition policy contributing to the European Green Deal. So this twin transition and all the challenges that come along with it have already started to pervade competition law and competition policy. The question that now frequently surfaces is the following: can competitive markets lead to market outcomes that are digital and green, or is it impossible to have both? Do we have to make a choice between digital and green, or can they work hand in hand? To explore these important questions, I want to start by highlighting some commonalities that you can find in green competition law and in digital competition law. What I understand by digital competition law is that area of competition law that deals with the digitalization of markets and the ever-growing presence of digital platforms. It also asks how competition law can contribute to advance the digitalization of the EU while maintaining a level playing field. Green competition law, on the other hand, discusses what competition law can contribute in order to further the EU's sustainability goals. What changes would need to be made to EU competition law in order to better promote these goals. So what unites green and digital competition law is, first of all, that they touch upon important policy goals that are laid down in the EU treaties. In digital competition law, data is regularly at the center of the analysis, because much of the digital economy revolves around information about users, about products, about competitors, and so on. And in this respect, data protection regularly comes into play that strives to protect personal user data from invasive digital practices. And data protection is also among the fundamental rights accorded by the EU Charter of Fundamental Rights. In a way, this is not unlike environmental protection laws that want to protect the environment from invasive practices. Environmental protection is also among the fundamental rights accorded by the EU Charter, and the United Nations recognized the right to a safe, clean, healthy, and sustainable environment as a human right only 10 days ago. At the same time, the digitalization of our lives also raises the question to what extent citizens have a right to access digital services and technologies, and to what extent big digital platforms need to remain open to smaller competitors. So one common denominator is that important public policy goals are intertwined with the green and digital economy that also need to be reflected in EU competition law. And as we heard, the EU's economic strategy wants to achieve a balanced green and digital economy. This further emphasizes the importance of getting this balance right. The integration clauses in the treaty provide a path to carry these ideas further. At the same time, it is clear, and this has been emphasized over and over again, that competition law will not be in the lead when it comes to greening or digitalizing the economy. But it can play an important role in supporting this transition by providing the rules that businesses must adhere to when they do business in Europe. A further shared characteristic is the nature of benefits that accrue to consumers. As I said earlier, price is a central parameter of competition law analysis. However, when it comes to making the EU's economy greener and digitalizing at the same time, I have found in my research that price may no longer be an appropriate parameter. More environmentally sustainable products come with an elevated price tag, but with added benefits, such as lower levels of pesticides, cleaner air, or slowing down climate change. A more digitalized economy will both extract more data from users and consume enormous amounts of energy, requiring us to carefully think about how much protection needs to be awarded to privacy and to the environment. While one could give price tags to all this, and in fact, economists have come up with ways to do just that, the question really is whether this is a good idea. Perhaps it is time to come up with an antitrust assessment that takes non-price benefits into account without necessarily giving them a price tag. Where price suddenly no longer represents the cornerstone of the analysis, the traditional analytical tools of competition will reach their limits, and new tools need to be developed or old tools revived and given an update. So a challenge that both green and digital competition will need to master in the future is finding a way to measure consumer harm and benefits related to, for instance, data protection, digital rights, and environmental sustainability. Also, while digitalization can benefit consumers pretty much right away, environmental harm or benefits typically accrue to a whole generation rather than to individuals. Here, the question also rises as to the time horizon that can be taken into account. It may be important to stop climate change, but this will not happen overnight. So the issue of the time horizon, which has long been seen as a challenge in competition law assessments, resurfaces here. Interestingly, both green and digital competition law come with issues of bounded rationality. In data protection, there's the privacy paradox. While most users state that they value their privacy, they often do not act accordingly in their online environment. Or perhaps they're not given the choice to do so. In environmental protection, there is the eco-paradox. Again, most consumers state that it is important to them to buy sustainable products, but in the shops, they often don't do this, or perhaps they do not have the means to do so. Here, the question arises how competition law can and should factor these psychological phenomena into its analysis, and how much it should nudge consumers in this regard. Let's move to a third and final shared trait: ecosystems and network effects. Network effects and network externalities play a central role in the digital economy because of the interdependencies that arise in digital markets. Digital ecosystems need to be increasingly focused on as units of analysis. But this also applies to the environment, where ecological ecosystems and network effects are at issue. The better one understands how to include network effects and ecosystems into the antitrust analysis, the more accurate the antitrust analysis will be, both for digital competition law and for green competition law. So to draw a short conclusion, what these shared characteristics allow competition law to do is to increase its ability to analyze competitive scenarios in which these issues arise. For example, when trying to incorporate data protection or environmental protection into an analysis. Here, digital and green competition law can give each other a helping hand to further develop competition law doctrine and also practice. So now that we have explored some of the commonalities that can help in devising a green and digital future for competition law, let's come to the more challenging part: possible frictions between a green and digital economy and green and digital competition law. It is clear that pursuing some digital goals will hamper environmental sustainability because of the energy consumption they lead to, because of the natural resources that are required, because of their exclusionary character, in short, because of their far-reaching environmental impact. As the EU pushes ahead with its goal of digitalizing our markets and our businesses, it will need to bear this in mind. There will also be cases in which prioritizing sustainability goals will be at the expense of more digitalization. For instance, certain collaborations that intend to further technical progress but require outrageous amounts of energy may not be tolerated based on sustainability considerations. And then, of course, we get to the point where it becomes clear that in order to achieve a green and digital economy, these two goals need to be reconciled in some way. Luckily, there will be cases where digital technologies can be used in order to pursue goals of environmental sustainability. For instance, a green tech company may work together with powerful digital platforms to lower the energy consumption of the platform's millions of users. This type of cooperation is already now unlikely to come within the antitrust prohibition of Article 101 of the treaty. However, it may also involve personal user data, in which case one should examine this case more closely. Another example would be a competition authority in a digital markets case that could choose a behavioral remedy over another because the chosen remedy is more environmentally friendly. There will also be cases where policymakers will need to strike a delicate balance between the two goals. For competition law, this will mean exploring how best to further market outcomes that do justice to both goals. For instance, researchers are now calling for a sustainable digital economy. This can include a circular economy that intelligently reuses precious resources, or green innovation that makes digitalization more environmentally friendly. Wherever this goal of a sustainable digital economy cannot be reached, competition law will need to ask itself whether a certain agreement between companies or a powerful company's unilateral behavior or a merger would prioritize one type of economy over the other, and what type of competitive outcome should be given a priority in the competition assessment. If it is our goal to devise a green and digital future for competition law, I believe we need to take 3 steps: understand, review, and adapt. I'd like to look at these in turn. As a competition law academic, my aim is to contribute to our understanding of how competition and competition law affect environmental sustainability and the digitalization of our economy, and how competition law can have a positive impact on a green and digital future. One needs to consider how dynamics that we observe in digital markets, like tipping and network effects, could be utilized for the good of a sustainable economy. Many digital innovations, like blockchain, can also have a negative environmental footprint. How do we consolidate this? What does it entail to attain sustainable digital markets? And what is responsible competitive behavior in such markets? In advancing our understanding of these issues, policy reports on competition law have been and continue to be of utmost relevance. But they usually focus on only one part, green or digital. What will be required is to have more understanding on green and digital. As a second step, we need to review the goals of EU competition law. And I just talked about the traditional view earlier. So what would it look like if we move to a more perhaps modern view on what competition law should bring to the markets? And this, of course, is inspired by these current debates. We would want sustainable economic growth. We would still want an efficient allocation of resources, but would also recognize that efficiency can incorporate sustainability benefits. We might choose a reinvigorated consumer welfare approach, where we acknowledge that not everything is quantifiable, and mere quantifiability sometimes simply misses the point. How would that look like? We might no longer strive for lower prices, but perhaps for fair prices, for true prices that reflect externalities. But then again, how do we reconcile this with consumers that simply cannot afford higher prices? We would still want a better quality of goods and services, but also of the air we breathe, the water we drink, the oceans, the climate, our personal data, our democratic choices, and online intermediaries. So we need to rethink the goals of competition law in a broader framework and recognize that we're not insulated from out-of-market concerns. We would also want more innovation, but more good innovation. So we'd acknowledge that not all innovation is good, and try to foster innovation that benefits the environment, social cohesion, and digitalization, towards a sustainable digital economy and towards a more sustainable economy in general. And this innovation aspect is something that I've extensively dealt with in my habilitation thesis. Then we come to customer choice. And bearing in mind the eco-paradox and the privacy paradox, we have to ask, should competition law be nudging consumers towards the right choices? And we know that this is rather dangerous territory. In the EU, as I said, we're also striving for a single market. And we already know that the economic strategy of the European Union is pushing us towards not only a single market, but a digital, sustainable single market. So we're already being pushed in this direction from the policy side. Let's now move to the third and final step we should take, which is adapt theories of harm and remedies. The idea is the following. Based on the understanding of how competition and competition law impact the environment and digitalization, and with a reinvigorated approach to the goals of EU competition law, it is possible to devise a coherent system of theories of harm that is mindful of the constitutional underpinnings of EU law and the Court of Justice's settled case law, and we can also structure competition remedies in a way that supports the transition to a digital and green economy. Now, this will not apply in each and every case, but perhaps in a surprising number of cases if you come to think of it. Few business endeavors are neutral when it comes to either sustainability or digitalization. Articles 101 and 102 of the treaty, as well as the EU merger regulation, allow us to adapt theories of harm because they contain non-exhaustive lists of anti-competitive behavior, and they're open to further development in this respect. More specifically, competition law can allow cooperation that furthers a sustainable digital economy and prohibit competitive behavior that harms it. It can promote sustainable unilateral behavior and step in where powerful companies abuse of their power. And it can give a fast go-ahead to mergers that are mindful of a sustainable digital economy and challenge those that would harm it. This transformation has already begun. Let me just highlight 3 cases here that illustrate this quite well. The first is, of course, the CESED case, which was decided by the European Commission over 20 years ago. In that case, European producers of domestic washing machines agreed to stop producing or importing washing machines with low energy efficiencies, so back then energy labels D, E, F, and G. And they also agreed to reach a certain efficiency. And this agreement covered 95% of the relevant market. The trade association, CESED, was to monitor this agreement. Now, the European Commission quite fast came to the conclusion that this agreement had the object of restricting competition under Article 101 of the treaty. It would raise production costs, and it would not meet demand for low-efficiency washing machines that existed in the market. And we know that by object restrictions like these are very hard to justify. But then came the question, would individual exemption under Article 101.3 of the treaty be possible? And the European Commission came to the conclusion that it was possible. It looked at 2 things. First of all, individual economic benefits, and secondly, collective environmental benefits. Under the first, individual economic benefits, it found that because the washing machines would be more energy efficient, consumers could actually recoup their increased purchasing costs through reduced energy bills within 9 to 40 months. And for the collective environmental benefits, it said and found that the benefits to society brought about by this CESED agreement through lower pollution were more than 7 times greater than the increased purchase costs of more energy efficient washing machines. So here, a sustainability initiative received competition law approval. Now, as I said, this case is over 20 years old. Today, we would need to ask, what if, say, a smart home application was added to the CESED case? So the more energy efficient machines were smart home appliances and connected to the producers and perhaps also the trade associations network. Digitalization introduces many new possibilities. For instance, data flows right back to the producers that can help in further developing energy efficient appliances. But there's also an increased danger of information exchange amongst producers. And we do know from offline cases that this frequently occurs through trade associations. And of course, digitalization here can facilitate that. So would such an agreement still receive competition law approval? Is it something that competition law should encourage because it makes the economy greener and more digital? Or does the smart home application increase the risk of anti-competitive outcomes? Here, learnings from earlier cases will need to be adapted in the light of new digital possibilities. Let's turn to two further cases, one green and one digital. The car emissions cartel case was decided over the summer. It was about collusion among major German car manufacturers on the technical development in the area of nitrogen oxide cleaning that in the end hindered green innovation, and the European Commission imposed a fine of 875 million euros. Back then, Margrethe Vestager, the executive vice president of the European Commission and also commissioner for competition, said, and I quote, "Competition and innovation on managing car pollution are essential for Europe to meet our ambitious Green Deal objectives. And this decision shows that we will not hesitate to take action against all forms of cartel conduct, putting in jeopardy this goal." So where green innovation is concerned, digital technologies can support these. While their role was not specifically considered in this particular case, it is easy to see how this dimension could be added to many green tech cases. One further and last case I'd like to talk about is the Facebook and Bundeskartellamt case, currently before the Court of Justice. This is a preliminary ruling that is pending on an important aspect of digitalization, namely the collection and combination of user data, and how infringements of the General Data Protection Regulation could affect competition law assessments. Now, as I said, this case revolves around the GDPR, which operationalizes the fundamental right to data protection enshrined in the EU Charter. But as I see it, this case will also be instrumental in understanding the relationship more generally between EU competition law and fundamental rights, including the right to environmental protection also contained in EU primary law. So current cases before the European Commission and the Court of Justice are increasingly seen against the green and digital transformation. And I do believe we can expect many more cases like this to be taken up by antitrust enforcers, allowing us to further develop competition law doctrine. Overall, to guarantee a greener and more digital future for the European economy, competition law as the basic rules for how businesses interact will need to balance effects on digitalization and on environmental sustainability. And it will also need to devise remedies that are in line with those two goals. Practically speaking, theories of harm can be adapted by changing how legal practice, so competition authorities, competition courts, and practitioners approach cases and analyze them. In this endeavor, competition law practice can rely on research that we are currently undertaking in competition law academia. But of course, there's also the option of going beyond adapting theories of harm and remedies through competition practice, and to include such goals explicitly in the statutes. And such legislative action is underway, albeit so far not green and digital, but either green or digital. For instance, the European Commission proposed a Digital Markets Act a few months ago to tackle competition issues connected to powerful digital platforms. Germany has just introduced its 10th competition amendment that foresees specific rules for digital companies of cross-market significance. And here in Austria, only a few weeks ago, a new provision was introduced that is an exemption provision for anti-competitive agreements that intends to foster sustainable cooperation amongst companies. And my analysis of this sustainability exemption is forthcoming in the Journal of European Competition Law and Practice. So, coming back to what could and should be done, we do see that there are many ways in which progress is being made in both green and digital competition law. What matters now is to reconcile the two in a meaningful way. The way to do this, as I suggested, is to understand, review, and adapt. So what does this mean for my research as a legal academic here at the VU? First, it is necessary to further our understanding of how competition law impacts a green and digital economy. This aspect definitely requires transdisciplinary research, also including environmental economics. So for this, I'm now ideally placed here at the VU. Second, a review of the goals of EU competition law requires an in-depth understanding of how these have developed in the past and how they can be shaped in the face of these new and dual challenges, but also against the background of the changing European Constitution. And third, in order to adapt theories of harm and remedies, All this knowledge has to be filtered into a coherent legal framework that needs to build on established case law, while at the same time catering to new realities. This is something that will take some time. And unfortunately, climate scientists are telling us the time is running out, because the climate emergency does not leave us all that much time. However, I am hopeful that with the research agenda I just presented, we in competition law can contribute to meeting this important challenge. And with this, I'd like to come to the end of my inaugural lecture tonight. I'm looking forward to discussing these ideas with all those of you who've been able to join us in person over a small reception that's been prepared just outside in the atrium. And to everybody online and here in person, thank you so much for joining us tonight.